All right. Hello. I greet you in the love and the light of the one infinite creator. We're going to get back on common law remedies, how to beat traffic tickets, having the law on your side. We're back at chapter 8, how to handle yourself in traffic court during a special appearance. And also chapter 9, competent record forming, the power of affidavits, and your identity affidavit of administrative notice. All right, so let's get started.
8. How to handle yourself in traffic court during a special appearance. Depending on the location, the town or city and state in which you have promised to show up in traffic court, you may be faced with any number of approaches in which the court attempts to gain jurisdiction over your person. Because greater numbers of people are becoming more aware and educating themselves about the fraud attending this issue of traffic citations, municipal courts are resorting to more inventive ways to entice people into consenting to jurisdiction. Just be aware that anything you sign or attest to can be used as prima facie, meaning, on the face of it, evidence of consent, opening the door to the court's pursuit of jurisdiction. Read everything that is handed to you very carefully, and know how to not consent by objecting or asking questions. For example, court officials may hand out, prior to the arraignment, a document entitled Notice of Charges, etc., and Preliminary Entry of Plea for you to look over and sign. This is a sneaky way to get you to admit to jurisdiction and to plea before you are even standing before a magistrate or judge. Do not fall for this trick. This is a sneaky way to get you to admit to jurisdiction and to plea before you are even standing before a magistrate or judge. Do not fall for this trick. If the form is being truthful in informing you of your rights, it will have a kind of disclaimer at the bottom in the form of a sentence which reads, "If you have any questions, do not sign this form." Whether or not the form has this sentence, or something like it, on it, you should never sign such a form. If they want to know why you are not signing, tell them you have questions for the judge. If they try to coerce you to sign anything, always put the words, under duress, under protest, or, without prejudice, above your signature, which should always be first middle name only, your true name, to indicate that you were being forced to sign, that this was against your free will. In a judicial court of record, under the common law, on appeal, this can be used to disqualify the document. Remember, you are attending this private court setting only in order to set the record straight and to challenge jurisdiction, not to testify, to swear oaths, or to plead to any unsubstantiated charge. All that the judge is supposed to be doing is finding facts. So establish all the facts around your refusal for cause, and don't allow yourself to become distracted from that objective. Stay focused, and stay on point. Once you have presented the judge with your refusal for cause, stand mute and say nothing more. If the judge asks a question, you can reply, "I have nothing to say. It's all in my filed papers, sir." Fundamentally, the arraignment is used as a clever way to obtain your consent. At an arraignment, the judge will assume jurisdiction unless you object. One way he assumes jurisdiction is by offering you three options of pleading: not guilty, guilty, or nolo contendere, or I do not contend the charge without admitting guilt. They never tell you that you do not have to choose any of those options, because as soon as you enter a plea, you've opted into their jurisdiction, and they can come at you. If they are persistent that you enter a plea, tell them, if there is no charge, no plea can be entered. What is being charged? And where is the charging instrument? No one can be forced to accept an offer. Service, a paper from a government corporate entity is an offer to contract. It is a distinct and separate offer from the one contained in a summons or complaint. You must volunteer to receive the papers, a consenting act. By returning the papers to the court, and by obtaining, witnessing, the date stamp on your certificate of mailing, you are refusing for cause the documents. When you rebut the unverified complaint filed into the case, you are filing into the case while remaining outside of the case by appearing special appearance to challenge jurisdiction. When a name sounding like your name, i.e., case of John Stephen Smith versus the state, is called, answer, no sir. I am John Stephen, first middle name, here by special appearance only, to make sure the plaintiff is not defrauding the court. I would like to tender a copy of this refused for cause presentment to the bench, please. To prevent fraud upon this court, hand over your documents, the photocopy of the citation with a refusal for cause written on it and your original certificate of mailing back to the presenter proving you have refused this action for cause, and then stand mute. Actually, you can walk out of court at this point and be perfectly within your rights to do so without being interfered with. However, if you do not completely understand this procedure, and the tricks that judges will use to compromise your position, you could possibly end up granting consent to jurisdiction by accidentally responding to a judge's order or direction. Therefore, if you aren't aware of exactly and precisely how to avoid contracting back into the jurisdiction, this can be a risky move. If, after you have handed over your documentation to the bench, you acknowledge anything at all that is said to you by the judge or any other court officer, such acknowledgement would be deemed evidence of acknowledgement of jurisdiction by the court, and you will be stopped and held over. On the other hand, if you are able to ignore whatever threats or entreaties that are shouted at you to stop or come back here, you will be allowed to leave. If a bailiff stands in your path on the way out, ask him to arrest the judge for treason, abrogation of his oath of office, and move on. Do not hesitate. Any hesitation or sign that can be taken as acknowledgement of the court will be used by the court as a sign that you have given consent to the court's jurisdiction, and you will be held over. Not many people have the emotional presence of mind to undergo such an ordeal. This is why it can be such a risky move. The above statement about special appearance is the first thing that must come out of your mouth, no matter what else happens, and no matter what the judge says, does, or asks you. Be aware that special appearance does not give jurisdiction to the court, but that general appearance does. Unless you specifically state that you are there by special appearance, then the court will presume that you give it jurisdiction by appearing generally. The reason you have to do it this way is because traffic courts are a form of what is known as a nisi prius court. Prius means first, and nisi means unless. What this refers to is a rule of procedure in courts, which essentially means that unless a party first objects to something that they know is untrue, then it is assumed that the party agrees to it and therefore the matter can go forward. The agreement to proceed is obtained from the parties first to indicate that the adjudication spoken of is one which is to stand as valid and operative unless the party affected by it shall appear and show cause against it, or take some other appropriate step to avoid it or procure its revocation. By entering your refusal for cause into the written record of the action, you have now switched the burden of proof to the plaintiff officer, and need say nothing more. Do not allow the judge to trick you into testifying by arguing any of the merits of their so-called case, or answering any question he may pose pertaining to the citation. For example, if he asks, "I see that you have violated section number 5321 of the traffic code. How do you plead?" You answer, "I have nothing to say. It's all in my filed papers, sir." Then stand mute. If the judge asks anything not having to do with the refusal for cause, then you can remind him that you are here by special appearance only, to challenge jurisdiction, and to please stay on point. Then stand mute again. By entering your written refusal for cause on the written record, you have placed into evidence a rebuttal of the presumption that you, the flesh and blood natural person, are liable for a color of law quasi-contract that is unreasonably favorable to the other party and which provides you with no remedy at law. This speaks to your right of avoidance, or your right to avoid an unconscionable contract or agreement. The likelihood that the officer, if he's still in the room, can prove jurisdiction is zero. Especially if you have signed the citation with a reservation of rights, without prejudice, above your signature, which fact can be pointed out in court if necessary. Yet, even without such a reservation of rights, if the officer cannot produce an original written contract that you signed attesting that you, or your legal fiction, would obey the traffic codes, he has no standing in the action, and the action must be dismissed. Stand your ground no matter how long it takes, and the action should eventually be dismissed. But do not be surprised if the only way to obtain your remedy is through your actions, by not accepting and returning, refused for cause, anything the court wishes to offer. Another thing to be aware of is to always refer to the state's case as this matter. Never call it a case, or else you will infer jurisdiction by presumption. They will presume that they have jurisdiction if you admit that they have a case against you. Take your time and think things through when facing any kind of questioning. The slightest hint of consent can hand your opponent jurisdiction, so stop and think before you open your mouth. Hold their feet to the fire of your refusal for cause, keep returning to that fact that they have not recognized or addressed yet, and box them in around this 2,000-pound elephant in the room, your refusal for cause that they cannot get around. Also know that there are federal codes in place that are meant to deter government officials and employees from bypassing your right of refusal and your rights in general. They can be criminally charged, as well as suffer civil litigation, at Title 18 United States Code, USC. Section 241 Conspiracy Against Rights and Section 242 Deprivation of Rights under color of law. 9. Competent record forming, the power of affidavits. And your identity affidavit of administrative notice. When having, and your identity, competent. 9. Competent record forming, the power of affidavits. And your identity affidavit of administrative notice. When having to deal with an administrative court system and legal entanglements, while at the same time endeavoring to maintain your unalienable rights, the most effective strategy you can employ is to keep and maintain your own documented records about the truth of your life. Because without that record, the truth will become lost in the shuffle of the statutory system. In other words, it won't be heard or recognized, and your chances of prevailing in the matter will be diminished if not outright nullified. If you find yourself in an administrative court, like traffic court, and you reasonably expect to be able to prevail in your position, you had better be able to document your truth, otherwise your opponent, the government, will document it for you within its jurisdiction. Thus far we have not touched upon the documentation that you can prepare ahead of time to help you establish your position in a variety of legal matters that may confront you as up against government itself. Ideally, you will apprise yourself of these matters long before ever needing to use them. However, in many instances, for one reason or another, we don't realize the importance of educating ourselves about these issues until the very last minute, that is, until after we have been confronted with having to defend ourselves in a matter at law. And then, it is often too late for us to expect anything less than being railroaded through the system. But take heart. There are things that you can do, even while in the very clutches of the beast about to devour you, which can turn the tables around so that those in the government system now tremble in fear of you. Everything that proceeds from this moment on in this exposition depends upon your having grasped an essential point involved in the concept of liberty, including, and most specifically, liberty from compelled performance by governments. That point being, if you want your truth to be told, only you can tell it. This necessarily implies taking personal responsibility for documenting that truth in a way that it cannot be denied by de facto government agents or officials. In other words, in a way that will discourage any officer or agent from thinking about, much less attempting, the rebuttal of your truth. In regard to competent record forming, let's look at an example of how to get on the record your reasonable expectation of being adjudicated in a court where the judge is obligated to uphold your rights under the U.S. Constitution. One of the first things you will want to look into entails whether or not the judge has taken a valid oath of office, on the public record, to uphold and support the Constitution. Be aware that some municipal judges have taken an oath in support of several jurisdictions, for instance upholding support of the Constitution of the United States, the Constitution and laws of the state of whatever state, and the charter, ordinances and laws of the city of whatever city. The oath, to be valid, should be sworn before a witness that the oathmaker considers sacred, usually God, as a witness to bind his actions in the performance of the duty of his office. Anything less than this is not a valid oath of office. Also, the word support in reference to the U.S. Constitution is important, since only a person who swears an oath to support the Constitution is bound by that oath. 2. Preserve, protect, and defend. The Constitution does not imply the same obligation in the legal world as the word support. Not even the oath that the president-elect takes contains this word, and therefore he is under no obligation to support the Constitution, although the public perception is fooled by this nuance. See example images of a valid and an invalid oath in the links below. The Dan May oath is an example of an invalid oath, while John Souther's oath is a valid oath. You will want to verify this oath of office by obtaining a certified copy of his notarized oath of office. This can generally be found by contacting your local county clerk and recorder, and, if not found there, sometimes the city clerk may have filed the oath to check if the judge's oath is on file. Obtain a certified copy of the oath in order to enter it into the record, filed into the court case, along with an affidavit from you accepting the judge's oath and thereby holding him in contract to its implementation. If the judge has no such oath on record or file, then he is impersonating a judge, and you can have him disqualified and arrested for such violation. All judges, by law, are obligated to maintain a publicly available oath of office, swearing, a promise or a statement of fact calling upon something or someone that the oathmaker considers sacred, usually God, as a witness to the binding nature of the promise or the truth of the statement of fact. When getting your truth on the record, it is often best to get it in writing, documented, so that later no one can deny that they were made aware of the facts being brought out in the matter. This keeps the judge and the prosecutor from colluding together to keep your exculpatory evidence out of the proceeding. When you have it in writing and have made it a part of the proceedings by entering it onto the record, it can be used later in an appeal to a higher court of record, if such becomes necessary. The power of affidavits. Just what is an affidavit and why are they so important in legal matters? And especially in legal matters involving commerce, or commercial law, which is more often than not the case in the majority of today's court proceedings. Black's Law Dictionary, 5th edition, defines a sworn affidavit statement as follows. Affidavit. A written or printed declaration or statement of facts, made voluntarily, and confirmed by the oath or affirmation of the party making it, taken before a person having authority to administer such oath or affirmation. To understand the importance that an affidavit can have in any legal matter, you first must understand that in today's world, nearly every matter that comes before a government court in America is presumed to have a basis in commercial law. And that commercial law is based on the maxims of commerce, which are eternally just, valid, moral precepts and truths that are recognized universally in virtually every civilized country in the world. The basis of commercial law is the law of Exodus, i.e., the Ten Commandments, of the Old Testament and Judaic, Mosaic, Orthodox Hebrew commercial law. The laws of commerce have remained unchanged for at least 6,000 years, and form the basis of Western civilization, if not all nations. Real commercial law is non-judicial and is prior and superior to the basis of, and cannot be set aside or overruled by, the statutes of any government, legislature, governmental or quasi-governmental agencies, courts, judges, or law enforcement agencies, which are under an inherent obligation to uphold said commercial law. In case you missed it the first time, let me repeat the significant passage embedded in the previous paragraph. Real commercial law is non-judicial and is prior and superior to the basis of, and cannot be set aside or overruled by, the statutes of any government, legislature, governmental or quasi-governmental agencies, courts, judges, and law enforcement agencies. Now, let the significance of that passage sink into your mind for a moment. Are you beginning to see what is meant by the power of affidavits? Non-judicial means that commercial law precedes any judicial setting or jurisdiction such as a government administrative or judicial court setting, meaning that, when the correct circumstances are invoked, it supersedes any judicial settings and cannot be overruled by the courts or the statutes of any government, period. Combine that with the fact that government officials and agents are considered actors under the law, in other words, fictions, and are therefore effectively foreclosed from swearing out an affidavit in rebuttal of a non-fictional sovereign's affidavit. Only like entities in standing may come at one another according to the law. The reason for this is simple, because government, its agents and office holders, is not found in nature, is not a natural phenomenon like a duck or a human being, and is a creation of the mind of man. It therefore is considered by law as a fictional entity that in reality has no substance and therefore does not exist to sustain injury. This means that government can never wield any authority over those who created it, unless the latter, by their consent, waive their right of avoidance and enter the government's fictional jurisdictional realm. Commercial law is a war of truth, expressed in the form of an intellectual weapon called an affidavit. An affidavit is merely a written list of facts or personal truths signed under penalty of perjury and usually notarized. The person composing and signing an affidavit is called the affiant. It is survival of the fittest, where the last unrebutted affidavit stands as truth in law, and thus as final judgment. In other words, in the case of an unrebutted affidavit, no judge is needed to rule. The law, regarding whatever issue that is at question, becomes self-evident and self-executing. This has its basis in the fact that since each individual experiences whatever he does from his own particular perspective in time and space, and through his unique nature and machinery of consciousness, all truth is subjective. Truth, like beauty, is in the eye of the beholder. 1. If someone expresses his subjective truth and others verify the same truth in their own subjective terms, said truth, as labeled as objective fact, i.e., the abstract map is acknowledged by others as accurately representing the territory and it is the right of the sovereign to express his truth in the form of an affidavit. The laws of commerce are expressed in 10 maxims, which are the eternal and unchanging principles of the law. 1. A workman is worthy of his hire. Authorities, Exodus 20:15, Lev 19:13, Matt 10:10, Luke 10:7, 2 Tim 2:6. Legal maxim, it is against equity for freemen not to have the free disposal of their own property. 2. All are equal under the law, God's law, moral and natural law. Authorities, Exodus 21:23-25, Lev 24:17-21, Dude 1:17, 19:21, Matt 22:36-40, Luke 10:17, Col. 3:25. Legal maxims, no one is above the law, and commerce, by the law of nations, ought to be common, and not to be converted into a monopoly for the private gain of a few. 3. In commerce, truth is sovereign. See Exodus 20:16, Psalms 117, 2, John 8:32, 2 Cor 13, 8. Legal maxim, to lie is to go against the mind. Oriental proverb, of all that is good, sublimity is supreme. 4. Truth is expressed in the form of an affidavit. See Lev 5, 4-5, Lev 6, 3-5, Lev 19:11-13, Num 32, Mat 5:33, James 5:12. Legal maxim, none. 5. A matter must be expressed to be resolved. See Heb 4:16, Phil 4, 5, EPH 6:19-21. Legal maxim, he who fails to assert his rights has none. 6. An unrebutted affidavit stands as truth in commerce. See 1 Pet 1:25, Heb 6:13-15. Legal maxim, he who does not deny, admits. 7. An unrebutted affidavit becomes a judgment in commerce. See Heb 6:16-17. Any proceeding in court, tribunal, or arbitration forum consists of a contest, or duel, a commercial affidavits wherein the points remaining unrebutted in the end stand as the truth in the matters to which the judgment of the law is applied. 8. He who leaves the field of battle first does not respond to affidavit, loses by default. See Book of Job, Matt 10:22. Legal maxim, he who does not repel a wrong when he can, occasions it. 9. Sacrifice is the measure of credibility. One who is not damaged, put at risk, or willing to swear an oath on his commercial liability for the truth of his statements and legitimacy of his actions has no basis to assert claims or charges and forfeits all credibility and right to claim authority. See Act 7, Life, Death of Stephen. Legal maxim, he who bears the burden ought also to derive the benefit. 10. A lien or claim, under commercial law, can only be satisfied by one of the following actions. See Gen. 2-3, Mat 4, Revelation. Legal maxim, if the plaintiff does not prove his case, the defendant is absolved. 10.1. A rebuttal affidavit of truth, supported by evidence, point by point. 10.2. Payment. 10.3. Agreement. 10.4. Resolution by a jury according to the rules of common law. Because truth is sovereign in commerce and everyone is responsible for propagating the truth in all speaking, writing, and actions, all commercial processes function via affidavits certified and sworn on each affiant's commercial liability is true, correct, and complete, attesting under oath regarding the validity, relevance, and veracity of all matters stated, and likewise demanded. Resolving disputes, law, requires a universally accepted means for someone to assert his subjective truth in a manner that all understand is intended to be uttered without equivocation, concealment, deception, or insincerity. An affidavit, especially an affidavit, sworn true, correct, and complete, has evolved over time to be the foundation upon which all statutory law is written and the accepted process by which someone expresses his truth in the most solemn, absolute, and ceremonial means possible, past which nothing else exists. An affidavit, as a solemn and sworn statement of truth and fact, automatically renders the affiant the subject of charges of perjury if any portion of his affidavit is proved to be false. Affidavit of notice and your identity. If the legal maxim, equality under the law is paramount, has any meaning to it at all, then whatever one sovereign can do, all sovereigns can do, due to the fact that all are regarded as being equal under the law, having equal access to all processes of law. Pragmatically speaking, this means that if government, a political incorporated sovereign entity as opposed to a natural sovereign entity, i.e., a man or woman, can give a notice to its presumed constituents concerning its intents and purposes toward its constituency, then the sovereign individual, being the creator of all existing government and, in a republic, ruling only over himself and no other sovereign individual, becoming in essence a sovereign without subjects, can equally serve notice on a political government regarding his intents and purposes towards some aspect of that government's operation. In order to better understand this concept of individual sovereignty being inherent in the people of America, it helps to revisit an early Supreme Court decision which speaks unequivocally to the recognition of the concept directly. As much as government would like to sweep the recollection of this decision under the rug, the fact remains that it is in the record and that its implication still stands. In Chisholm v. Georgia, 1793, Alexander Chisholm, the executor of the estate of Robert Farquhar, attempted to sue the state of Georgia in the Supreme Court over payments due to him for goods that Farquhar had supplied Georgia during the Revolutionary War with Great Britain. Georgia, for its part, refused to appear in court, taking the position that as a sovereign state, it could not be sued without granting its consent to the suit. In a 4-1 decision, the court ruled in favor of the plaintiff, Mr. Chisholm. What is important about the case is the key principle expressed in the written opinions from the majority side. The opinions concluded that, to the extent the term sovereignty is even suitably applied to the newly adopted Constitution, it rests with the people, rather than with state governments. This thought was expressed by Chief Justice John Jay when he wrote, the Revolution, the sovereignty devolved on the people, and they are truly the sovereigns of the country, but they are sovereigns without subjects. With none to govern but themselves, the citizens of America are equal as fellow citizens and as joint tenants in the sovereignty. Less well known, yet equally if not more striking, are excerpts from the opinion of Justice James Wilson, the man who, just a few years prior, had introduced the original jurisdiction clause at the Constitutional Convention in Philadelphia. Justice Wilson characteristically struck right at the heart of the matter when he stated that he knew the government of that state, Georgia, to be Republican. And my short definition of such a government is one constructed on this principle, that the supreme power resides in the body of the people. Furthermore, he rejected the feudal notion of state sovereignty on the ground that another principle, very different in its nature and operations, forms the basis of sound and genuine jurisprudence. Laws derived from the pure source of equality and justice must be founded on the consent of those whose obedience they require. The sovereign, when traced to his source, must be found in the man. In years past, the actors holding office in American government were much more aware of their tenuous positions as servants of the people under the structure of a republican de jure, or, according to law, government, and therefore needed only the slightest reminder of such to correct their actions whenever they sought to go outside of the bounds of their delegated authority. But ever since the war between the states, often referred to in history books as the Civil War, when Congress, on March 28, 1861, adjourned without a quorum sine die, or, without date to reconvene, even though the Constitution fixed dates for their regular sessions, the country has been run de facto. In fact, and not, according to law, as originally intended, through the unconstitutional use of the law of necessity, under declaration of a national emergency, which is essentially de facto martial law rule, and Congress has never yet been reconvened under law. If you doubt this, documented historical fact does not lie, and you can look up the following Senate report issued by this same de facto government and read it for yourself. The Introduction to Senate Report 93-549, 93rd Congress, First Session, 1973, summarizes the situation as best as possible. Since March 9, 1933, the United States has been in a state of declared national emergency. A majority of the people of the United States have lived all of their lives under emergency rule. And, in the United States, actions taken by the government in times of great crises have at least, the Civil War, in important ways, shaped the present phenomenon of a permanent state of national emergency. And ever since the passage and ratification of the 14th Amendment to the Constitution, in 1868, and the subsequent congressional formation of a corporation for commercial agency and government for the District of Columbia, in 1871, at Chapter 62, 16 Stat 419. Which later was reorganized in 1878, at Chapter 180, 20 Stat 102, and renamed United States Government, and having privately trademarked the names United States, U.S., United States of America, USA, and America. The de facto federal government has operated under a doctrine of assumpsit or presumption. Assuming all people identifying themselves as a citizen of the United States, as being subject to the jurisdiction thereof, 14th Amendment, meaning the United States government incorporated in the District of Columbia, thus, legally, transforming, at least prima facie, everyone into subservience to the government. The only problem with this is, it will not stand under the light of day, and only stands by one's failure to withdraw their consent. In order to rebut this presumption that you are subject to the jurisdiction thereof, it is advisable that you be able to document this fact so as not to cause the government actors, agents and officers confusion over this issue. This can be neatly done with an affidavit giving notice of your identity, notifying any government official who presumes to know your political venue, of your stated on the record political status, thus removing the onus of presumption. This is why the concept of being able to self-identify yourself with your own documentation when confronted by public officials is so important. Without it, you are presumed to be subject to the jurisdiction of the state, county, city or federal territory in which you happen to find yourself. In other words, if you don't state your truth and your law in the form of a declaratory affidavit, in effect providing notice to government officials, then the de facto government will, lacking any evidence on the record to the contrary, assume you to be under its jurisdiction and governance, and it will proceed against you on that basis. When composing your affidavit, there are a few things of which you need to be aware in order to ensure that your affidavit meets the criteria of what the law views as being a valid affidavit. Affidavits are testimony that set out facts. They cannot state conclusions of law and they cannot be argumentative. If an instrument is either of these, it does not qualify as testimony. Regardless of what it is called, it does not qualify as testimony by affidavit in a court of law. Following list of characteristics and properties comprise those which should be fundamental to any affidavit that you compose. 1. An affidavit should only state facts, truth, on the basis of first-hand, personal knowledge, not conjecture, theory, or hearsay. The facts stated must express the direct knowledge of the affiant, not information and belief, which is hearsay. 2. The affidavit should not be argumentative, that is, they should not make legal arguments. You only want to lay out the facts in an unequivocal manner such that your adversary, or a judge, will have no trouble understanding anything that you are asserting as being your truth. 3. The affidavit must not draw conclusions of law. If written properly, the conclusions you want drawn from the presentation of your affidavit should be apparent and self-evident. When composing an affidavit, make either short, positive statements of fact and/or negative averments. Place the burden of proof on your opponent. An averment is a formal statement or declaration asserting some fact or truth. A negative averment is an assertion in which a negative is asserted. For example, if your opponent, and/or the court, assumes a fact about you which is untrue and which has not been entered into evidence, a negative assertion will force your opponent to provide the evidence on the record, or be stopped from making the positive assertion. Rather than stating an opinion as a negative, I did not run a red light. Instead state, I am not in receipt of a verified complaint naming an injured party as a result of any of my actions. The implication being, the action of running a red light. If there is no verified complaint from an injured party, there is no case. In other words, there is no claim upon which relief may be granted. 4. The affidavit must be certified, witnessed by an officer of the state authorized to administer oaths, usually a notary public, or assigned witnessing by 2 or 3 people who personally know the affiant firsthand to be the person he, or she, is claiming to be is sufficient under the common law for a sworn verification. If it is not so sworn, it will not be considered to be a verified affidavit. In addition, each page must be signed, usually at the bottom right-hand side, by the deponent, the person making the affidavit. 5. The affidavit should have all paragraphs numbered, for the purpose of identifying particular points or passages for future reference should a rebuttal by the opposing party be attempted. 6. Your affidavit should contain as many points of fact as possible to state your truth, each of which must be rebutted under oath by your adversary. The more points, the more formidable. 7. An affidavit constitutes one of 3 kinds of testimony, the other 2 being a deposition and direct oral examination. Additionally, it stands as uncontroverted evidence, or truth, in the matter if not timely rebutted point for point by a proper counter-affidavit executed by the adverse party. 8. The affidavit must be executed with the following verbiage as being sworn, true, correct, and complete, that is, under oath, defining the degree and nature of the commercial liability being claimed by the affiant for the veracity, accuracy, relevance, and verifiability of everything stated in the document. 9. An affidavit can be invalidated or nullified only by being rebutted point for point by a counter-affidavit sworn, true, correct, and complete. Your affidavit will stand as the truth concerning each point that is not rebutted by counter-affidavit as above. The entire affidavit stands as the truth in the matter if it is not answered at all. 10. Your affidavit will stand in full as the judgment, application, of the law, under common law, if your adversary fails to rebut it any or all of the facts stated by counter-affidavit as above. This invokes execution of the law concerning the points in the affidavit that are not expressly rebutted in a counter-affidavit. 11. To be valid, your affidavit needs to contain an express certification of the facts contained therein by the affiant. An exhaustive swearing used as the closing statement in a commercial process would be: I, the undersigned affiant, swear on my own commercial liability, that I have read the foregoing instrument and know the content thereof, and that, to the best of my knowledge and understanding, it is true, correct, complete, and not misleading, the truth, the whole truth, and nothing but the truth. A less exhaustive, but still very binding closing statement is: I certify that the foregoing is true, correct, complete, and not misleading. It's interesting to note that use of the phrase true and correct is not the same as true, correct, and complete. True and correct is perjury by omission as to every material matter, whereas the addition of the word complete alludes to the aspect of the material matter of the statement. Finally, always place a reservation of rights before, above, your signature. Subscribed and sworn with all rights reserved, without prejudice, no value assured, or something similar. By making your choice of law known through your affidavit, you are challenging the jurisdiction and venue of the setting. Be it in a court of administrative law or the court held out on the street by the attending officer, who presumes you to be within his jurisdiction. When you properly rebut the presumption, the fictitious charges, if they indeed are such, miraculously disappear.
Alright, well that's it for this video. Next video is going to be addendum. What happens if I follow this advice and things go wrong and I fool it up? Please like and subscribe. Leave a comment. Let's get the conversation started. And I hope to see you guys next time. Until then, I leave you in the love and the light of the one infinite creator. Peace.